Hi, guys. It's Kathy. I hope you're doing well. And I hope you don't mind staying in one courtroom today because Thursday is Mental Health Day with Judge Arnold. No, Judge Blanco. And, she's very soft spoken and very gentle, but man, she's got a bunch of, she had a day. She earned her paycheck today, and we're going to watch it. We're going to watch all of it. We're going to stay there all day. Let's go. Oh, no. We're not watching shit. YouTube saying nope. I guess it'd be my computer saying you're not watching shit today. It's okay. It's okay, computer. I'm just in the middle of a stream. It's fine. Please continue.
The court process with me.
There we go.
They're going to help you with looking for housing, transportation, any of that kind of stuff. They're kind of your key to the outside world to kind of figure out what can be done to support you. So you've got Mr. Iddings, and now you're going to also have Bridges appointed to help you. Be aware they'll come out to visit with you soon. And I think at this point, Mr. Iddings, we've already ordered the evaluations in all cases.
Has it been ordered? I don't know if it's been ordered on the two cases I just found out about this week. Does it need to be ordered in all four cases?
I will order in all four, just so the reports go in all four as well. Some of these will get dismissed potentially if the results come back that he's not able to sufficiently aid in his own defense. And I don't know if I've already ordered it, is my question.
I don't know that we have, Your Honor. It is my request today that we do order evals.
Okay. Yeah, Mr. Beller, the evaluation is just
Colorado.
to help me. I'm trying to figure out how much of court you're able to help.
And before you ask, it's all counties. So I think there's 2 mental health courts in Colorado now, not just one. So all counties, if they say, that you're not competent, you need evaluated, you either go to her courtroom or Judge Arnold's courtroom. So, this is Larimer County right now that he's in jail at, but it could be any county.
Defend yourself against the accusation. So I want to know how much you're able to direct Mr. Iddings in your case. So a doctor's going to come out just to evaluate you on that. I'd ask that you cooperate. If you want to talk to Mr. Iddings before you meet with the doctor, that's totally fine. But we need to clear this hurdle. I need your cooperation to do that. Not a normal doctor's appointment. It's not a private meeting. It really is just to help me get a good glimpse of whether or not you can adequately defend yourself against the accusations. Okay? Do you have any questions?
Sorry, Your Honor, they just made an announcement in the facility and I missed the last part of that you were saying.
Yeah, that's totally fine. I can repeat. So the evaluation, when the government accuses a citizen of a crime, I need to make sure the citizen can actually defend themselves in court. And so the evaluation is for me to get a glimpse into that. So please cooperate, do a good job. If you want to talk to Mr. Iddings before you meet with that doctor, that's totally fine. It's not a normal doctor's appointment. It's not private. They're going to write a report for me so that I can see whether I need to provide some extra support to you. So please help us get that hurdle cleared, okay?
Thank you, Your Honor. At this time, I need to find out who can reach out to Michael Patrick at the Patrick Law Firm. He's I've known him for a long time, and I was wanting to reach out to see if he might be able to help represent me as private counsel. Who would I speak to about that?
Mr. Beller, I tried to come out to visit you. This is Mr. Iddings. I'm your public defender while you're in competency court. I wasn't able to get into your housing area, but I will be out to visit you before you get evaluated. And when I come visit you, it'll hopefully be next week. I'll talk to you about that. But right now, I'm your court-appointed attorney, but I will be able to reach out to that attorney on your behalf after I meet with you, because right now I'm the attorney of record.
Okay.
So it sounds, Mr. Iddings is gonna meet with you, and then if you need some help reaching the other attorney, he's gonna work out kind of what that plan could look like. But because I've appointed him, or Judge Ellison, whomever did, Mr. Iddings will come out to visit you to see how he can support you in your request, okay?
Okay, Your Honor, it just seems like a rather kind of lengthy, drawn-out process when dealing with the public defenders. So I've dealt with them in the past and they've been great, but Michael Patrick, I fully trust him and I'm fairly confident in his ability as an attorney. And like I would prefer, and he'd probably be willing to help me out pro bono or something like that, because I want to make sure that I get the best representation possible in this case. And
So couple of things. You have the right to have an attorney of your own choosing. It'll be your responsibility to pay for if you make a different arrangement with this attorney. That's fine. You can do that at any time, and
Okay.
we can substitute him in. I will remind you right now, the prosecution of this case is kind of on pause for me to get this evaluation back. So Mr. Iddings will still come meet with you, and then if you need the other attorney, that's totally fine. We'll just substitute him in if the attorney is wanting to represent you. So sounds like Mr. Iddings will come meet with you, see how he can help you get connected, and if that lawyer wants to represent you, that's not a problem.
And could you remind me of his name? Because I can try to send him an email.
Your Honor, I would like to fire the public defender's office at this point in time, because it's only because of the public defender's office that the competency thing was raised to begin with. So we wouldn't have to be going through this competency thing if you know what I mean? So I feel like.
Hang on a second. So, I want the eval done, and then if you can fire them, that's fine. If you want to substitute another lawyer, that's fine. But right now, I think that you're having a natural reaction a lot of people have. It's like, why did they do this to me? They are being protective of you because they don't want you to be prosecuted if you're not able to help defend. A lot of these cases are going to be dismissed if your evaluation says you need extra help. So it's actually a very protective thing that they had done for you, and Mr. Iddings can talk with you about that more. So you seem super open-minded. I'd ask that you meet with this lawyer before you make some decisions about what you want to do, okay?
Yeah, Your Honor, I understand that. It's just that I'm sitting in.
I ordered
23 and 1,
McDonald's.
like, housing, so it's not like, time is a precious thing, and like, I only get 1 hour out of my cell a day, so it's like next week is like quite a long ways out, so.
Okay.
I can try to email him today if you give me his number, but you don't want to have no attorney, because then things are really going to be drawn out. So I'm on your case right now. What's his name?
Michael Patrick of the Patrick Law Firm in Berthoud, Colorado.
Thank you. I'll reach out.
So let's
Thank you very
reset
much.
this case, no problem, till August the 7th at 2:00. And I'll set it for potential bond review. If we get an evaluation back sooner, Mr. Iddings, let me know. And if Mr. Patrick wants to represent you, he can file into the case, and I'll take care of your substitution before then.
Okay, Your Honor. Is there any ability to address bond today as possible PR bond?
No, there's not, but I will visit that with you when we come back. And
Thank
so this time we were not on notice of that, but next time we will be.
Okay, thank you, Your Honor.
It's
All right,
30
have a good
minutes
day. Thank you.
away. 30 minutes. I'm
Let
starving.
me go ahead and pivot to,
I had a banana here and someone took it. I hate living here. I don't want to live here no more. I want my banana back. My banana was going to get me to breakfast. All right. I should be working there.
present before the court. He's in custody, and Mr. Krenning is here as
Don't worry. This guy is way more sane.
his counsel. Hi, Mr. Stein.
I've almost been murdered a few times. Like, people have assaulted me with intent to murder. And that's a lot of the problem is because they're starting to run me over at the bus stop, and it was starting to
That's how I feel. My family assaulted me with the intent to murder me when they took my banana. I'm with you, buddy. We're the same.
smash in my face and defecate on my face. Josh Wells was, and I did what I did to avoid being murdered.
Okay.
Like
So-
intent to threaten.
Yeah, it sounds like you've had some time to talk to Mr. Crenning and you've made us aware. I'm glad that you told me that. We're here today. It sounds like Mr. Stein was accepted to Valor.
That's true.
I don't even know if we're victims' rights compliant to address that, Mr. Osmacher.
We were able to get compliant for today, Your Honor, so we can discuss that.
And I
Yeah,
guess
he did.
Mr. Stein seems like he has very high needs. Is Valor able to maintain and support his needs? If you know more, Mr. Oxmacher, I welcome you to educate me.
Yeah. Your Honor, here's my position.
Just a second.
Mr. Stein has been in custody a fair amount of time. His case under the statute will time out in August. I think this is a situation where we don't have perfect
Kids
options.
are at my mom's house.
But one option is to wait until August and just have the case time out without him participating in a supportive program. Our other option is to authorize the outpatient restoration plan, allow him to be transported to the Valor program and see if that's something that can assist him. And so when looking at those two alternatives, the fact that we have a supportive service, I think we should give it a try.
And is the victim okay with that, or do you have any input?
Yes, we discussed this with the victim, and they are supportive of the attempt.
Okay. Mr. Crenning, what would we have to modify with bond to assist Mr. Stein to get there?
I think we would probably need to make it a personal recognizance bond conditioned upon his transport to the Valor program in Colorado Springs and him remaining there and compliant with their rules and regulations. Just a minute, just a minute, just,
Mr. Stein,
I'm
not
told-
your turn.
I'm told that transportation can be arranged on July the 7th. That's 11 days from now. We've talked about that. Mr. Stein would like to have that all.
I'm going to use that more often. I'm going to use that more often. No, it's not your turn. It's my turn. Your turn's later. Just wait.
Opportunity if it's available to him. So I think all we need to do, if I'm not mistaken, is adjust that bond to a personal recognizance with those conditions.
Do we have a plan?
We do, if I can approach.
Yes, please. Mr. Stein, eyes on me. I'm gonna go over the plan with you.
Yep.
Okay, eyes on me. I'm gonna walk through this plan with you. I want to let you out of jail. It's gonna be on July 7th at 9. And you're gonna be able to live at the Valor House, but you have to follow their rules and some rules for the court. Are you willing to do
Those
that?
poor people.
Okay, so you're going to need to keep in touch with Kenny, Anna, Nick that have been working with you. They've been visiting you at jail, and I'm going to give you a copy of this paper. It has their name and their phone numbers on there in case you need to reach out to them, and they'll be reaching out to you. And it sounds like when you're working with Nick, you're going to not contact Tim Younger, who's a police officer here in Fort
I
Collins.
don't even remember who he is. I don't remember who he
Exactly.
is.
So you're gonna be just fine. It's not.
He was violating his own restraining orders.
So you don't know him, so you're not gonna have to worry about it.
I barely remember his face, but I don't know who he.
That's fair.
He kept arresting me and trying to target me for violating restraining order.
Okay.
And I saw the guy get attacked, and I was there when the guy got attacked. I was witness to it, and they charged me for violating restraining order, and I was witness to the crime, and I was just trying to explain to him what happened.
Okay. Well, it sounds like you're gonna be able to stay away from him. You don't wanna have anything to do with him from the sounds of it. This is enhanced, so you'll be communicating with Nick pretty frequently. You need to be law abiding, and you need to essentially stay at the Valor program and follow all their terms and conditions. Take your medicine like you do as prescribed by your doctor. Can you do all of those things? And you gotta follow all their rules at Valor. Can you do that? Okay. The court is going to modify this to a personal recognizance bond and adopt.
It just sounds so different that way. I would just love a cheese and bacon omelet. It sounds so different. It sounds like a completely different piece of food item than a bacon and cheese omelet.
The outpatient restoration plan as the bond conditions.
Hard to keep the totality.
He knows, he knows. Pay attention.
Like we doing some pretty messed up stuff.
Okay, well, you're gonna be at Valor and you're not gonna be in custody anymore. And so you're gonna be releasable to the competency team. They're gonna help you with getting transportation out there. Let me give you a copy of this so you have everyone's phone numbers and you can remember all the things we just talked about. Just wait right there. We'll make a copy and bring it to you.
He's going to be calling them all the
Do you have any
time.
questions, Mr. Stein?
Just there was lack of intent to threaten. It was self-defense and defending others because it was letting people get away with committing crimes.
Okay, all right. So that's something Mr. Krenning will process for you as your lawyer, but for the meantime, I'm excited to see how you're gonna do. You're in orange today. That means that you're not, misbehaving in the jail. And I want you to keep following rules when you get to Valor too. I'm proud of you that you haven't, ended up in a red outfit. And I want to see you succeed while you're at Valor.
If you're accusing somebody of something, they get defensive, they're guilty of it. And usually another thing, it's usually if someone's accusing you of doing something, the other one's doing it.
Okay. All right, but this is.
It's called reflecting yourself on the others.
But this is a nice opportunity for you to have some housing and kind of get back in the community and have some support. I don't know when the last time is that you had those things. In a while?
And another thing, it's that there was a cop that was arrested for child molestation. And that had a lot to do with my attitude about the situation because the cop got arrested for child molestation.
Okay.
And I'm when there's one, there's got to be more, like, big suspects.
I'd like to visit with you.
I'm wearing
You
red.
can be
I'm going to wear red
Arrested for
today.
Child molestation.
You can be virtual when you visit with me. We'll let the Valor program know so they can help you. When would you all like me to revisit this case?
It's a 30-day program.
He's moving on July 7th at 9. He'll need a chance to get acclimated to the program there.
Look at the Thursday on the 7th or 14th of August, maybe?
Sure.
Fine.
Is that too far? Are you okay with that?
Child molestation, it must have been one did it.
Mr. Stein, eyes on me. August 7th, we'll set this matter in at 3 if you're available, Mr. Cunning.
I am.
Okay, August 7th at 3. You can be virtual. I want to see how you're doing. I want you to represent my courtroom well when you go there, okay?
I talked to the Nashville CEO, and they said that the cops keep having sex with kids and they keep getting away with it and they keep beating the polygraph test somehow.
Mr. Stein, no, please. All done with that. Go ahead and we'll have July 7th. You'll be moved to Valor. All right.
Well, they're taking him there. So they're not just letting him go to walk there and get there on his own. They're taking him there. And if he doesn't stay, then they'll know and they'll get a warrant and they'll pick him back up. So it's not as oh, that's wrong. All right. Next.
Yeah, deputies at Mobile One. I don't know if you're moving the cart to Jacob Hatley.
This is the mobile unit, Your Honor. I apologize. Are you ready for Mr. Hatley?
Well, I am if that's where you're going.
Trust me. None of us are ready for Mr. Hadley, and it's okay because we don't get him because we are not ready. We are not prepared to handle him.
I'm happy to call this case early. Okay, thank you so much. It's not a VRA case, so we can do that.
Thank you.
All right. Let me know when you're ready, Deputy.
Oh, wrong person. Never
Ready when
mind.
you
It's
are,
the
Your
next guy we're not
All
ready
right.
for.
Court calls the matter of Jacob Hatley, cases 25M948, 25M475. He's present before the court. He's in custody, appearing from the jail. And Mr. Hatley, I do want you to know that your attorney, Ms. Lowry, is here in the courtroom. I am going to appoint Ms. Lowry into 25M948. Ms. Lowry, Do you want me to adopt the findings in that case?
Yes, please, Your Honor, and because it's only a DM1 and a paraphernalia ticket, I did presumptuously file a proposed order to dismiss that case.
Any objection?
No objection to that case.
Okay, give me 1 second. Let me jump into that case, Mr. Hatley. The law says that that case needs to be dismissed because of the findings we just made. So let me sign the order and that case will be dismissed. But you do have another case, and that one is not eligible to be dismissed. So we still have to handle that other case for you with the harassment charges. And so it seems to me that your client, Ms. Lowry, that you, Mr. Hatley, do pretty well with your medication. Well, do better with your medications in the evening. Maybe you're not a morning guy. I have no idea, but if there's a way to kind of communicate and see if Dr. Ziegler might be able to, if it's appropriate, modify maybe some of this regimen of this medicine, maybe that could be helpful, because otherwise, Mr. Hatley, everything I hear from Emily is that you're very pleasant. You're a very nice person as far as how you interact with her, which I always appreciate, but that you need some support with your wellness, and we need to kind of help you stabilize. So please work with Dr. Ziegler and trust him, so that if Dr. Ziegler and you have a plan for your medicine, you're actually trying to do it 100% of the time. That way he can see if it's working, and if not, he can help adjust it with your health. So please try to be consistent with your medicine plan that you've worked out with your doctor. Ms. Lowry?
Yes, Your Honor. With the 25M948 case being dismissed, Mr. Hatley has only the 475 case, which has a $50 cash bond. I do want the court to know he does have some municipal cases he's currently being held on, but I have been advised by the city prosecutor that she is filing to dismiss those based on this evaluation as well. Mr. Hatley cannot post that $50 bond. He is wondering if the court would consider modifying that bond to a PR bond. Right now, his only housing option to propose to the court is that he stay at the shelter, but he does want to work with Emily. He's willing to go to the classes. We did have a conversation about taking evening meds instead of morning meds.
Okay.
So I'm hoping that Dr. Ziegler will take a look at that soon, but Mr. Hatley is asking the court to consider outpatient restoration. But that's really all we have to offer in terms of a proposal.
Yes, and I'm going to just say this to you, Mr. Hatley. I would love to see you out of custody. However, I look for when people are stable, and some of the things, you don't have to have housing. If you have a plan to stay at the shelter, I can live with that as long as I'm confident that you're going to follow through. I do want to see your wellness taken very seriously when you're working with one of our professionals, Dr. Ziegler. You have a plan, you're not following the plan. So for me, I am not feeling very confident that you're going to follow through with my other professionals that work with the court. I'd like to see some additional stabilization and some additional effort from you. And what I'll tell you is when we come back to court, I'm happy to address the bond again. And you can develop a plan with Emily, but your track record, your actions speak much louder than your words. And if you're doing that, then I will also rise to the occasion in hearing your request, and likely supportive of it if I see that that's happening. So today I'm going to deny the request. But we will visit this issue again to give Mr. Hatley a chance to kind of show what he can do between now and then, as far as creating some stabilization. And the recommendation is to come back on September the 4th, Ms. Lowry, at 2.
I'm wondering if you might consider something a little earlier than that, if you had any room on one of your early August dockets.
My reports are that he's not doing very well right now. And so if he's on medication, I think that will be a huge help to us. Let's do this. It's not a VRA case. I'll set it on September the 4th at 2. You're visiting with him, Emily's visiting with him, and if his medication regimen changes and if he's engaged that, please add him onto the docket. I think you're a good gauge of when the court will revisit that bond, and let's set it for a bond review. Mr. Hatley, you have my word that once things look stable, to a place that the court will likely be satisfied with a plan for you, Emily and Ms. Lowry can let me know to bring you back in, but I want to see some decent track record from you. And I'll see you back as early as you've kind of brought that track record back in order. Okay, I see you nodding your head. You've got my word and I want to see what you'll do. I hope to see you earlier, but I'll see you no later than September 4th. And I think everything else is in order. Thank you. Thank you, Deputy.
So he was doing okay, not great, but okay. We finally got one that was doing a little bit okay. Okay. This is the one we're not ready for. And we don't get them because we're just not. We hear about them though, don't worry.
I have court for you. With that, you're not, okay, I will let her know. He does not want to participate, Your Honor.
Okay, well, thanks for getting a few more steps in, Deputy, and appreciate that. All right, we will go ahead and call his matter regardless at this time. And Yusuf Fofana, 25-05070, 25-0399. He has refused to participate in court today. And though the deputy was just there offering it virtually, his attorney is here in the courtroom, which is Mr. Iddings. So I hear that there is a report, Mr. Iddings, and that the report that came in, I have not seen it, but the team has, is on your second eval that you requested, and that it does indicate ITP findings should be adopted. Let me make a greater record because I'm not sure if the prosecution or you, if you have the same information that I do.
And Your Honor, just in the interest of time, the DA did get a copy. As soon as I got a copy, I forwarded to the DA, and it's my understanding that he does not object to adopting the finding of the second eval and finding him both incompetent and tier 1.
That is correct, Your Honor. I would ask the court to adopt specifically the tier 1 status. I will note that the evaluation also indicates that short-term certification he might qualify for. I'm not pursuing that at this point, but I note that kind of further supports this tier 1 status.
I have Isaac here or someone.
He unfortunately is ill today, Your Honor.
Okay, well, that is very unfortunate, but someone's passing along some information. It sounds like maybe to him from today's court. Logan, are you in touch with him?
Your Honor, if you're putting the record into the minute order, you will have access to that and further assistance needed.
Explain why. Okay, we will make sure that we take sufficient notes on this minute order. The court is going to adopt the finding that he is incompetent to proceed at this time, that he should be a tier 1A specifically. It should be noted that Mr. Youssef is taking his meds fairly regularly. And even though he has been seen by Dr. Ziegler consistently, and he is taking medication quite frequently, he is still on a 1-to-1 red tag basis with a special management plan in place.
It's pretty gross,
This
guys.
is due to the fact that Mr. Fofana has had multiple behavior reports, not only for inappropriate comments, but most importantly, because he's been throwing bodily fluids, his bodily fluids at people, underneath the door, by throwing his own bodily fluids, he is placing himself in danger. He's placing our deputies in the jail in danger. And right now he's on a red tag status. Otherwise, arguably, if he was anywhere else in that jail, he would be placing the other inmates in danger. I will also note he is very aggressive with the deputies in the jail. As a result, they cannot enter his room to clean his room. And knowing that there's bodily fluids essentially everywhere, the fact that he is living in those conditions because no one can enter the room to clean it has the court highly concerned about his health. There also is an issue that he is not bathing, that there are hygiene concerns for this individual. And so for these reasons, the court finds that a tier 1A status is most appropriate for Mr. Youssef. Any objections to those findings or any additions?
No objections from the defense.
No objection, Your Honor.
And so that will go into place. Mr. Iddings, given that you want to come back in 1 or 2 weeks.
Either one is fine, whichever docket has more availability.
Well, nobody wants to be with me on the 3rd. So you're here though, right?
Yes.
Let's do it 3:30 on July 3rd. To get an update, maybe even from Isaac, where we stand on this case. He should be moved within 7 days, but that doesn't normally happen. And Mr. Iddings, if you can even get any updates, and I'm sure Kenny will too, just from the jail to see whether there's further deterioration. So I need to make an additional record, I can. All right, thank you.
Oh, I almost went to get my food without putting another one on. I'm not really hungry after that last clip, though. I don't know why. I lost my appetite. 4th, 5th.
Let's call the matter of Robin Musso, 2401094. And is Miss Musso going to be? Oh, she's here. She's present before the court. She's out of custody. Ms. Lowry is present as her counsel. Morning, or good afternoon. Good afternoon. All right, and so it looks like we had the evaluation returned to the court. Have you had a chance to review it?
I have, Your Honor.
Is there any objection to it?
I should say that Ms. Musso would like the court to accept the findings and the evaluation, but I have consulted with her counsel in both the misdemeanor case, which I really wish was in this courtroom, and I'm still not clear why that posture in the misdemeanor is different than the felony. But speaking with her counsel in those 2 other matters, we are requesting a second evaluation, and Dr. Joshua Hatfield has agreed to do it. He thought he could complete it by the end of July.
Okay.
But I know Ms. Musso objects to this request.
Give me one moment before you object. I promise I'll hear from you. Give me one moment. I just want to say something because often when people hear that their lawyer is taking that position, it's really easy to feel like this lawyer is against me. Like I don't want that. Understand that, and I don't know what the misdemeanor counts are, but there are certain counts that would be dismissed, for example, if the results of the evaluation were different. And the lawyer is always trying to protect you ethically. And so it may not feel great, but I will tell you that the lawyers, and I used to be a defense lawyer, are trying to take a protective position around you for whatever that's worth. And so by law, if it's requested, it's on my tab, not on yours or hers. But by law, if it's requested, I'll order it, but you get to pick who. And it sounds like Dr. Hatfield is someone that your lawyer is saying would be probably most beneficial for you. No, your lawyer is trying to pick who she thinks would be best for your case.
Just became aware of all this today.
I see. That's overwhelming.
Yeah, so, I have been deemed competent, and that's what the judges had mentioned. They said, we want to put you over there to do an evaluation only. Once your evaluation comes comes back competent, you'll come back to our courtrooms and we'll proceed with trial. So that's exactly what I did. I complied to their requests.
Yes, you did.
I did the evaluation as per their request.
Yep.
And I've been found competent. So I just would like to move on with going to trial and put this behind me, as I have, 2 jobs that I need to be at, I have a family I need to raise, that all this, and I would think it would be a misappropriation of court funds to do a second evaluation
Even if
in a couple weeks.
Even if I agree with you, by law, I have to order it. I just want you to know, you and I are in a similar posture. And so it may come back exactly the same. And I'm not going to bring you back sooner because I respect that you're working and you have a family. I don't want to make this more burdensome, but I get where you're coming from. Okay. Prosecution.
Thank you, Your Honor. I understand that the court has no choice but to grant the request for a second evaluation. This case, as Ms. Newsom mentioned, is pending trial. We are about halfway through speedy, and although speedy is told here, this case should not have come to our docket given that the procedural position.
For the misdemeanor or the felony?
The felony.
I see.
And so actually, Your Honor, my request today is that the court order the second evaluation, but set the next court date on the 5A docket.
I see.
Be back in Judge Gerard.
Right, so here's what I'll do. I will order the second evaluation. You're right. I have to. So that's going to be ordered, and it can be done by Dr. Hatfield. That's quick for a second eval to be done. Just a moment. My word to you is I'm not going to bring you back sooner. Let me look for a court date in Division 5A with Judge Gerard. That's right after the evaluation comes back, and then Judge Gerard will help you. If it comes back consistent, Judge Gerard is going to resume your trial. If it does not come back consistent, the lawyers can have a hearing on that issue, and Judge Gerard would be who hears that case of that hearing. So you still have some options, but you and I, as the lawyer, as the district attorney pointed out, we have to complete the second evaluation. Okay.
May I speak?
Just 1 second. The trial has been vacated, is what Ms. Whitfield is telling me, and so.
The trial has been vacated. However, they are still in the middle of speedy.
Okay, so they just told speedy, but they haven't waived, or reset.
And the not guilty plea has not been withdrawn.
I see. All right, now back to you.
So I would like to, if there has to be a second competency hearing, may I hire my own personal forensic psychologist to do so?
That's a great idea.
So I would like to have an open court objection to this. But
Your objection is recorded.
Okay.
That's recorded. This is a doctor who is being paid for because they're willing to take our state pay. So as long as you have someone who's certified,
I believe I do. Yes, ma'am.
And so let's make sure you're coordinating that. I just don't want to waste time. And I know you don't either.
I have been wishing for that same thing for over a year now.
So all I can tell you is, that is really fast for us to get an evaluation back.
Instead of getting her evaluation done by the lawyer that her defense attorney picked out for her, she wants to get her own. She wants to go get her own, not lawyer, doctor, psychiatrist.
By the end of July. I can tell you that I'm familiar with Dr. Hatfield, and they do this work for the defense side regularly. And so why don't you learn about Dr. Hatfield? And then if you want to pay to have your own person, and if they meet the credentials that Judge Gerard can accept the evaluation, otherwise it's just going to delay you even longer. So why don't you research Dr. Hatfield and then see what you think about that? But I'll issue the order now so it doesn't make it take even longer. And then you can communicate with Ms. Lowry or your other attorney if you want to hire somebody else, so they can also, they're watching out for you, make sure that it's not somebody who we can't accept, okay?
Also with, with the order going through, can we just go ahead and schedule Mr. Hatfield right now so that I don't lose a spot?
Yeah.
And then that way, if before, if I find that, okay, I'm gonna choose my own, then we can just, take Mr. Hatfield off and.
Yes, but unlike the other doctors, I don't have access to Dr. Hatfield's calendar. And so Ms. Lowry will help you to get in contact and schedule that appointment, but I'll issue the order now for you. And then let me get you another court date in front of Judge Gerard. When the DA was saying, basically when competency was raised, it paused everything. But the time that you already were entered your not guilty plea, that has racked up and has paused, but it has not reset. And that's why you're going to go back to Judge Gerard, because as soon as the competency finding goes in, it resumes the clock again, and Judge Gerard needs to reset your trial.
Can I ask a question?
Yeah, for sure.
How come my first competency hearing hasn't been accepted?
Yeah, so
Or my
by,
evaluation part?
yeah, by law, if a request for a second eval is made, the court has to order a second
No
evaluation.
matter where the request comes from?
Correct. And so,
Even if there's an objection?
correct. And
Okay.
so, this sounds like such a terrible thing to say, but it's like the legislature has written this. We, including me, who's taken an oath, has to follow even whether we agree or don't. And so I don't know if you were here earlier when a victim was objecting to sealing a record. I don't have any authority to not seal it. If a second eval is asked for, it's coming straight. I'm the chief judge here. It's coming out of our budget. That's what I have to pay for and do. And so I respect what you're saying. I hope you also know I can't do anything different. So we just get through this together and let's get it cleared as quickly as possible. If the eval comes back sooner, have your lawyers bring you back to court sooner in front of Judge Gerard and the other judge that you're in front of.
So I won't be coming back here for the findings of the second eval. I'll be going to 5A.
You'll have to go to 5A because the trial is pending.
Yeah, I would like to. I would like to just get it over with. And
I will not take that personally. Give me just 1 second. Let me get you a new court date.
Kit Kat, I would card you if you came to my bar. I would card you.
August 1st at 9:30.
To be kind.
August 1st at 9:30. Is that too quick, Ms. Lowry?
It might be a little quick, but I know Ms. Musso is anxious, so I'm going to just try to hustle Dr.
Especially because Judge Gerard is in trial the following week. So let's get in front of him August 1st, 9:30 in 5A. Okay, and we'll put the order in right away.
Right.
Okay. Okay.
So
If you put another one, I just have to see if they meet the state standards and accept state rates, and I can put it. I'll set up.
does that mean you guys will pay for them too?
State.
Oh, okay.
If they accept those rates.
If they, okay,
Right.
thank you.
Thank you. All right. I have,
She has more crazy.
M5094 25M370.
Is this the guy? Hold on.
414
Hold on.
is present before the
This is the
court out
guy.
of custody.
Guys, you are going to love and hate this man. He's gonna annoy the crap out of you. Yep.
Oh, good. You're one step ahead of me. You have that earpiece. And so, can you hear me okay?
I'm doing fine, thank you.
Good. And all right. And so Ms. Lowry is here as your attorney. And I think I just wanted to check in, kind of see what the plan is. Ms. Lowry.
Your Honor, this was a case that was going to be referred for the wraparound program, but since it's a little slower to get started than we had thought, we've actually reached an avert agreement that Dr. Aldrich has already signed.
Please. All right, Mr. Aldrich, did you have a chance to review this paper?
I did, Your Honor. I thought that it was a very generous offer. I have had contact with the good work being done up at Summit Stone in the past. I met personnel again here today. I don't know Gateway, but I'm very, very supportive of social services throughout the country and here in Colorado.
Wonderful. Well, I'm glad you've had positive experiences. My experiences have been the same as yours. And I am glad to hear that we share that in common. So this agreement is essentially telling me that if you do these requirements, they are going to dismiss your case. And so I'm looking at this and I'm not sure for how long this.
We're thinking 45 days.
Okay. And so I'm gonna look for a date 45 days
Yum,
out.
Scott.
Between now and that review date, you need to not get any new charges with the police. So you need to be law abiding. And I want you to verify your Medicaid long-term assistance and engage with your comp team. You work with Emily, and so you'll keep working with Emily. Return to court for your review. And then, like you said, you're used to Summit Stone, you'll do your intake there and work with them and connect with Foothills Gateway, they're great. And so it's unfortunately it takes a little bit of time, but once you're connected with them,
Sure.
there's some really great opportunities there and great community there. So
Thank you, Your Honor. It's been a very valuable experience too, here at the Justice Center. And I've learned so much about the law. And looking at it from my viewpoint as a psychiatrist, retired, it's given me much to think about. And I'll be thinking about those things as I obey the request of the document of the court. And I'll see you then in 45 days. So,
get your review date. Where were you a psychiatrist?
yes.
Was it here locally?
No, I was in private practice in Columbus, Ohio. I graduated from Loma Linda University School of Medicine, and then my psychiatry residency was at Ohio State University.
Okay.
And I worked with Department of Corrections as a forensic psychiatrist consultant for several years, part-time. So I have a warm spot in my heart for the work that you do and the things that I learned about the law. Apart from having testified as an expert witness, I knew very little about the law and how you do things. But
Yeah, you were on the other side of things after people had gone to prison, it sounds.
you learn more from that than you do. You're blind to so many things when you're the one that's doing the work. And one of the primary rules of psychiatry is to make yourself aware of the countertransference issues. That was Freud's term for it, but that means be aware of how your own values and biases and ignorance, which I had much of about the law, color your decisions. I've been involved here as a pro se, and while there were a lot of losses, including what I'm dealing with now, I learned so much. And I haven't met in the 3 months I've been doing that anyone else that was as involved with examining the pro se experience as I was. So I'm interested in writing about that and talking to one or two of the judges when it's appropriate after I've dealt with it.
I don't know what happened, guys. Don't ask me, but everybody's names are coming up as their YouTube names. So stop saying hi to MJD. It's Martha, guys. Say hi, Martha. You already did.
These issues and learn more about how I might understand, things like mediation. That brings psychiatry or behavioral sciences in, like all of these folks here, Bridges and Summit Stone and Gateway. We're all available. And I think some of the best work from my perspective from law has been mediation, because it takes into account some of what we can offer as well. So I'm very interested in learning more and continuing to write about about the connection and the similarities in the ways we can work together.
That sounds great. Well, it's not often that we meet someone who can take a
Not you, Terry. Terry, your name's coming up normal. And you, Scott. Isn't that weird? Something weird's going on. Oh, never mind, Terry. It's all messed up now. As soon as I said that.
the circumstance that's this challenging and see that there's something that, you know, can contribute to growth and knowledge and experience. And so I think you are approaching
I'm gonna ban
this,
you.
you know, in a
I'm gonna
way
ban
that
you.
I
I'm gonna
only hope
ban you
other
from this
people would
channel.
as well. And so I thank you for all of the things that you've said and considered. Sorry that I haven't called you Dr. Aldrich. And so I have not been properly addressing you all of this time. But I'm going to approve your agreement with the district attorney. And I'm going to give you a review date of August 7th to return to court at 3 o'clock in the afternoon. And I'm going to write that down for you. And that way we can give you a copy.
Donald,
Do you have any questions?
how can you be sure Kit Kat's a girl?
Ma'am, I know, Your Honor.
What if she's a guy and you've been calling her Kitty? That would be hilarious, Kit Kat.
I don't. Thank you so much.
My pleasure. And I'm glad that you were able to work this out. Sounds like your lawyer and the DA were able to reach something reasonable.
I saw that. I was very appreciative of it. It took into consideration a number of factors that you might not have been aware of. So intuition, thank you, sir.
All right. Well, though I appreciate our conversation, I'm not going to see you till August 7th. So do well. And on the 7th, when I see you, that's the day that hopefully your case will be dismissed.
Thank you, Your Honor.
Have a good day.
Pro se, he said he volunteered as pro se. I'm glad that you volunteered as a pro se, sir. All right, we got 2 left. Here's the second to last one.
4
Terry.
o'clock docket. And let me just give me one moment on the Stuckey matter. I'm going to call Timothy Vester first, 24 CR 5230, 24 CR 1160, 25 M619. He's present before the court. He is in custody. Ms. Lowry present as counsel. Love to see you in that outfit.
I'm trying.
I know that outfit tells me that you're trying because you're an inmate worker and you were before too. Yeah. And so what happened?
I guess my hand's broken again. I was in the kitchen today this morning and tried grabbing the pan. I'm a cook, and the hand got stuck between the kettle and the steamer, and I broke my rods again.
Oh,
So I got to get surgery done again.
oh no. Are you in pain?
Yeah, I'm a lot of pain. It's okay though.
Well, no, that's okay. I'm sorry. That does not sound pleasant. I have a broken bone in my hand. I didn't ever have to go have surgery.
No, Judge, you're not allowed to speak. Sorry, you keep your stories to yourself because you're not allowed to speak right now.
But I was supposed to have a pin put in it, and I
I have 2 pins and 3 rods.
You have 2 pins and 3 rods? Yeah, no, I was a violinist and my parents were like, she's not gonna have surgery unless she has to.
Yeah, I play piano, so.
You do?
I do, yeah. I took piano lessons when I was a kid.
When's the last time you played?
I think it's been a very long time, and it was like one of the things after the drugs kind of took over, just kind of stopped. But I enjoy still playing piano. I have to go back to it if I had a chance.
You should. That's my relaxation instrument is to play the piano. Yeah, the violin is stressful for me because my parents had me in like competitions. The piano is relaxing, so well done. All right, I'm going to take a look at your report, and I do want to highlight 100% med compliant. We know you're an inmate worker. You know, this is the good stuff that was, you know, genuinely had built up before we went down the path that led us to you being back in custody. And so it feels like you're back on the horse, so to speak. In structure, you do extremely well. And no doubt that it seems like
I hope you were nice.
there's been an acceptance into the foundry because they see all of the good in what you've been doing. They've been a really
Damn it, Kit
great,
Kat, come on.
They've been a really great partner, stakeholder, you know, and have really had a lot of success with some of the people in our court.
They're really hands-on, so that's what got me really excited. Like I have a learning disability, so that why STIRT wasn't really good for me. And I've done STIRT 3 times. It's mostly book work. I have struggling understanding what they're talking about. And then I get really emotional. So when I talk, I think one of the main issues I was having struggling, like changing my life around from drugs, was that I was not willing to open up to the things that really have causing those problems for me because of the people I was around. And people, I live here in Fort Collins, so I'm going to be impatient with these people. And there's things I can't say, even in the courtroom, I can't say, get I done. And I think being out somewhere that I'm not, where I don't live, I could be out more open and honest about what's really going on in my life and my problems. And so I'm really excited about that. It's somewhere that I'm not living. So once I'm done with the program, I can let it all out and see if they can help me with it and then come back to where I live. You know what I mean?
When you let it all out, that can be very triggering.
Yeah, I'm talking about like my struggles.
No, I know. That's what I'm talking about.
That's what I think it'll be good for me. There's things on my shoulder
Sure.
what made me so think about this is when the day before I got done with STIRT, something came up and I just spoke to all my caseworker, my therapist, and the director there, and I told him what was going on, and the reason why I was acting so bad, having all the seizures, and I noticed that like I don't know, like a weight was lifted, but just like
I don't know if you heard her at the beginning because her voice is so mellow, it's hard to focus, but he's had 2 seizures in front of her before in the past.
I felt like it was good that I told somebody about all these problems that I had. And
Yes, I think
I didn't
telling,
know how to handle it or talk about it to someone about
I
thinking I was a bad person.
no. So you're not a bad person. You're not a bad person. You're not. I mean, some choices that you made, maybe, you know, are not choices that you would agree with now or that people would agree with. I might not agree with them, but who you are as a person is different than the choices that you've made. And I think you need to separate some of that. I mean, you can be accountable, you can reflect, you can feel remorse. You can recognize that that was not a great decision, that was a bad decision. But you also can still be a great person, right? Like in all of that. And so I truly believe, and the day I don't believe that anymore, I don't think I will be sitting up here anymore. But when you talk about all the things that have happened, it can be really hard to resurface all of that. It will be very liberating and it may be challenging all at the same time. One. The second thing is, I wish that there was a special place in Colorado that there are no drugs. But I'm not familiar with that part of our state because everywhere, if you go looking or if it falls in your lap, I mean, it's just part, sadly, of what our country is going through. You need to use tools and you need to trust the system, whether it's the foundry, whether it's ERT, you know, you got to be someplace where you're like, I am invested in this, and have a plan that if you're in a difficult spot, you're actually communicating and reaching out to these folks.
I think that's one thing that's been different this time, even though like if I don't get this chance or whatever, like I'm not going to give up. Like I noticed that I don't want to keep using drugs. And one thing I know the difference is this time though is that instead of using and keep using, I use and I try to ask for help or I take help.
Yeah.
So like I know I don't want to keep using drugs and it's going to be there no matter what. I just got to learn how to, like I said, like fully use my skills.
So
and
you're,
accept skills. I think one thing I found is I didn't want to accept skills. Like it's too easy. It's not that easy. And I would doubt myself a lot. So like I'm trying to, like I said, I really got to open up, let stuff out, open up to letting these skills be used around me and like the deep breaths. Like it's not petty. It's really helping. I thought it was petty. Like it's people gonna laugh at me if I do this. So like I really want it. So like I was saying I want to let everything out and see if
okay,
it would help me.
I know.
I have that. What else choice I have? What?
Mr. Vester, your body is healing from the choices, you know, every time substance is used, it takes a long time for everything to heal. And it's not going to be overnight. It's going to be a journey. And if you're invested, I mean, your mindset is right. It's just kind of like figuring out the tools and how you're going to use them, you know? So with all of that said, however, you've got a pretty significant bond, and I think we're addressing bond today, if I'm not mistaken. And are you VRA compliant, Mr. Mangione, to address bond?
We were intending on addressing bond, Your Honor. I guess, is the bond already been set?
Yeah, I've set bond in all three cases, or yes, and so there's a co-PR $10,000 bond in 24 CR 5230 and a $15,000 cash surety bond in 24 CR 1160. But 25 M 619 is a summons, and I believe that there's a request to dismiss it.
Pending motion to dismiss, yes, Your Honor.
It makes no objection.
So I'm going to dismiss 25 M 619 because I am required to by law. So give me one moment. I'll sign that. Let me hear from Ms. Lowry first, just to see what the request is, and then I certainly would like to hear from you, Mr. Mangione.
Your Honor, our position when the bonds were set, we didn't really take any position. We just wanted the bond to be low enough so that Mr. Vester could be eligible for inmate worker. And so we didn't really give any input other than that when those bonds were set at that amount. I'm hoping the court would consider modifying them to straight personal recognizance bonds with the condition that he be released on June 30th at 9 a.m. To one of the members of the competency team, Lauren. Foundry has agreed to pick him up, but she could get him set up with pretrial before releasing him to them. What I wanted to point out, I did file the acceptance letter from the Foundry with the court. And what they noted was that the primary focus of Foundry is to treat men and women who've experienced adverse life events, experienced trauma, or have been unsuccessful in other treatment programs. I think when I look back on, I mean, Tim obviously did so well while he was in jail, and then he went to work release. And I know the court was cautioning him to maybe go a little slower when he was eager to get back to work and go into Lighthouse, but he was really eager to go back to work and maybe moved a little more quickly without realizing that the treatment pieces were not quite there. Then at work at 7-Eleven, he was robbed, you may recall, and I think that just sort of contributed to a little bit of downfall, but he never like fled the area. Like he said, he did use, but he didn't then just go on a total bender. He went into custody, no problem whatsoever. And he's not been any issue. And we haven't tried to ask for him to be released before now, and wouldn't have asked for him to release to a program in this community, because what he has shared with the court and what he had already learned when he was coming in was that he thought he would do better outside of Fort Collins, where he doesn't know anybody, where he'll feel free to be open about some of the issues that continue to plague him in a different setting. And just given the track record with the Foundry and their record of working with people who've not been successful in other programs, it does seem like an awfully good fit. I'm hoping the court will give him this other opportunity. He's been in custody now for over a month and is clean, is ready to learn everything he can from this intensive residential treatment care.
Mr. Mangione, I don't know if you were aware, because I know you're normally not covering our docket, but Mr. Vester is one of the victims in another one of your cases from an incident in 7-Eleven while he was working. And so it does seem like it was one of the contributing factors to how we got off track. One, your position.
Keep rubbing it in, Kit Kat. Keep rubbing it in.
And just so you know, I did discuss these cases with Mr. Axmacher, so I'm not going rogue here or anything like that. But our position is to leave the bonds unchanged. Frankly, and the reason I was confused is something in our system. I thought those previous bonds had been vacated already. It turns out I was wrong. So I'd ask the court to leave them as is. I understand certainly that relapse happens. That being said, my understanding is the team really put in a tremendous amount of effort to get his parole discharged. After he had picked up these new F3s, he was placed in the work release program.
Wait, how
placed in the
offensive is
Lighthouse
that?
program, and
I need to
understand
know.
that there are various circumstances that can lead to relapse, but the reality is he did. And I think given all the efforts that were put in place to create a successful environment for him in the community, and he was unable to maintain that, I'm going to ask the bonds remained unchanged. I think he's obviously doing better now, and I imagine that has to do in large part because he is in custody and is being monitored and has a secure place. So I think the bonds are appropriate. I understand that might put a crimp in the plans to get him to the foundry, but I'd ask the court to leave them unchanged. Thank you.
What about the victim? Has the victim provided a position to you?
Let me see if I didn't, let me check one more
I
time.
think it would be in the 24 CR 1160 case if it exists.
That's what I'm looking at. I don't see any specific input for the court. We did send out a letter. I just don't see any, I have no specific input for the court, Judge.
One moment.
They're all pondering. Pondering, I say.
This affidavit from the felony matter involving the burglary of the dwelling was from the allegation of entering into the garage to steal things from the car. Does that match your understanding of the allegation? Okay. The court is going to modify your bond at this time to a personal recognizance bond in each of these two matters. I really don't want to be wrong. I mean, I'm looking at you and you've had a rough go and you've overcome a lot of adversity. And I fundamentally do understand that relapse is part of a recovery journey. And I understand some of the circumstances, but I can't be wrong when I put my faith and confidence in you because the community trusts me to make decisions that are safe. And I don't want to be wrong about that. And so I'm just telling you, if we're in a situation like this again together, I don't know that I will be able to do this another time. And so legitimately, if the things that you're saying to me are true, then you're giving me your word and I'm trusting you. And you're going to have to follow through, which means when times are tough, you need to lean on the people at the foundry. Will you do that for me?
Yes, ma'am. Yes, ma'am.
As the conditions of this modification, the court will transfer this into an outpatient restoration plan, whereby the foundry is where you'll be residing. You'll follow all terms of their program and successfully honor their program's rules. You'll be law-abiding. And I want you to stay at the foundry. You may not change your residence, okay? You're going to stay in contact with Brandy at pretrial. Remember that they're going to do substance monitoring. The court has ordered no drugs, alcohol, or recreational marijuana. And if you sign a release, the testing you're doing at the foundry will work, but you need to sign a release. And that I'm going to cross out report to parole because that's done. Take all your prescribed medication as the doctor has prescribed. Stay in contact with Lauren and then start taking the classes for restoration when it's time. Court will make you releasable on your personal recognizance bond in these matters on June 30th.
You can be nice.
Sunday at 9 o'clock in the morning.
Smile. Did you try
directly to our
smiling?
competency team. I'm going to sign this plan that you've also signed so that you can have a copy of it. Please. I really believe in you and I hope so.
Good job, Judge.
Monday, let's come back to court. You can be virtual and let's check in and see how things are going in a couple of weeks. Ms. Lowry,
The
that
movie.
brings me again to the 10th. Let's set it at 4:30 on July 10th, just to check in and see how things are going. Your client can be virtual at that time. Do not walk away. Do not pick up new cases. Buckle down and do the work. I know you can. See you in 2 weeks.
No, he
Judge, one
can't.
point of
He's going to get
clarification.
picked
Are
up.
those amounts the same, 15,000 and 10,000?
Just gonna flip them into PRs. Thank you, Mr. Mancioni.
Just flip
for
him
that
into PRs.
clarification.
I just have really good news, though. Guys, it was like 750 degrees out today. And I was stopped on the highway picking up my daughter from work. On the highway, I was at a dead stop. And my air conditioner kicked on. It's been years. It was lovely.
Lindsay Stuckey, matter is 24 CR 273. She's been patiently waiting in the virtual courtroom, Mr. Watson. Her counsel's here in the courtroom. And Ms. Stuckey is appearing virtually from our jail. And I do appreciate that.
I'm sorry, Kelly. You're right. It wasn't 750 degrees. It was 750,000 degrees today.
Counsel Mr. Webster is here on behalf of the Attorney General's office. Dr. Engel is here with the Office of Civil Forensic Mental Health. They're both appearing virtually to assist the court in navigating what is a very complicated circumstance. Dr. Engel, thank you for joining us. Wanted to speak with you for a moment because I'm not sure if it has been brought to your attention. But it has been brought to mind that as recently as Monday, Ms. Stuckey was trying to self-harm and trying to successfully complete taking her own life by choking on the only item that she really has access to. That's a feminine hygiene product. And that was on Monday. The court has escalated concerns about her safety, her wellness. And though I'm understanding that you have very limited beds for women, this person who is on my docket
Judge gets really, really, really mad here.
Is extremely unwell, and the jail is really not equipped, as you well know, to handle the circumstances that Ms. Stuckey needs. And so I really need to understand as our partner what you're doing to get her into treatment in one of your spots.
Your Honor, may I speak on behalf of the department briefly?
Sure, Mr. Webster.
So the department is aware of that, and as the court's aware, we are out of compliance with the statute. Ms. Stuckey is 21 on the wait list. As to her particular situation, the Department of CFMH has been looking at alternative options to ensure that she gets the help that she needs in a prompt manner. What I have learned from my conversations with Alan Marshke, who's the judicial liaison, is that the most recent encounter she had with clinical staff at the jail, Dr. Ziegler, I believe it was, he was informed that they believe that she meets criteria for a 2765 commitment. One potential option to get Ms. Stuckey into care is to pursue a short-term certification under 16.8.5.111 subsection 3. That section permits the courts to authorize the filing of a petition for short-term certification for an individual who is incompetent, regardless of the opinion on their restorability. The logistical barriers to doing that, first and foremost, is who would initiate the petition. At present, there has not been an OCFMH clinician who has had direct contact with Ms. Stuckey on a recent enough basis to form that opinion. Ideally, it would be jail staff to initiate that petition. The second barrier that I have seen with this would be the individual's bond status. When an individual is transferred to a short-term certification, to put it bluntly, there is no guarantee how long that certification will last. They'll be transferred to a designated facility where the clinical staff there will stabilize the patient and then in their clinical judgment determine when they are safe and appropriate to release. So the bond status does present a barrier because if she were potentially released from that, there really is no compulsory way to return her to the jail if that's appropriate. So the bond would need to be modified and there'd be permission for outpatient restoration services. So, again, the department is out of compliance. We do understand that she's 21 on the wait list, but in brainstorming, that is a potential alternative route that could be explored in her case.
That does not seem like a safe route, nor am I VRA compliant to modify somebody's bond at this time. Again, when someone is tier 1A status, this person has tried to, again, as the situation has gotten worse, as of Monday, the department is out of compliance with statute. All of those things are fact. And so my question is, she is a 1A, tier 1A status. There are 20 other 1A women status above her.
I believe there are
20 people that are 1A status ahead of her. Because I've adopted this finding from April 29th, understanding that there's not as many women's beds. I'm confused how she became 21st on the list, council.
So the list is both male and female.
I see. Where is she on the female list, council? Because obviously those beds are different, right?
Right. So the wait list, and if Dr. Engel has that figure, welcome him to jump in, but the wait list is not necessarily who's been waiting the longest.
Agreed. I'm well aware, council.
Yeah.
I'm very familiar.
We know that there are 18 women who have been waiting longer than her. I don't have that exact figure on how many women are ahead of her on the wait list.
In regards to acuity, I guess is my question, because that's my understanding of how OCFMH is trying to manage these beds for the safety of the individuals that they are responsible for, is to move the most acute. And again, with the record that's been made, what occurred on Monday, certainly we all are well aware if somebody is in confinement the way that Ms. Stuckey is, it is extremely detrimental to someone who is in need of care at such a high level for mental health support and management. And so I believe she has further deteriorated from the record of what's been presented to me on as recently again as Monday. And so I would say she's incredibly acute given the circumstances. And I'm wondering where on the female list she sits given her acuity. And it sounds like Dr. Engel, you may be able to help me with that.
Yes, Your Honor. There are currently 10 tier 1 females on our wait list that have been waiting longer than Ms. Stuckey. 6 of those 10 women are only eligible to be admitted to CMHIP. 2 additional are making that up to 8 are able to go into either Pueblo or Fort Logan, leaving 2 individuals ahead of Ms. Stuckey who are eligible for basically 3 of the hospitals. So Pueblo, Fort Logan, or Peakview. So
She's eligible. Sorry.
It's a good idea. This set the jail that she's in, it's not equipped to handle someone who's self-harming. Like they would just have to like tie her down. I don't know, but that's a great idea. That's something they can do until a bed opens up.
Sorry, doctor. Thank you for helping educate me.
Thank you.
She's eligible for all 3 locations. Is that what you said?
that is correct.
And that's based on her charges and
That's
that all 3
Terry.
facilities can meet her psychiatric needs.
Yes, ma'am.
And that seems like it would open up more possibility for her movement because I know the female beds are very limited. And I do want to make sure that our record is clear that she's a tier 1A. I don't know if that changes anything for you to be able to move her.
I certainly can investigate it further to make sure that our data is correct, but from my looking at it yesterday, I do stand behind the numbers that I have provided.
And what would be a realistic, what is a realistic time frame, doctor, that she will, I know you don't know for sure, I'm very familiar with this. I'm not saying it to trick you. I'm trying to figure out when to reset this. What is a realistic time frame? I want my sheriff not to have to worry that he's essentially acting as a mental health hospital, trying to keep her alive and safe so she can get to you. What's a realistic time frame that she'll be moved roughly?
Given that in May, the average wait time for an individual, male and female, who was a tier 1 was 63 days. And at this point in time, Ms. Stuckey is at 38. I would say roughly within the next 4 weeks.
I thought I issued this order on April 29th. Is that what you're showing as well, Counsel Webster? Because if that's accurate, that puts us actually at 58 days.
Your Honor, I am showing from the e-filing register of action, May 22nd, I believe, unless I'm missing something.
Well, no, I might be. Give me one moment. Mr. Watson.
Your Honor, that's what our records reflect as well.
Give me one moment. So in front of Judge McDonald on April the 29th, the court adopted the findings from the Weld competency evaluation, finding Ms. Stuckey to be incompetent to proceed. And
I fear
that
for
was
Micah.
sent into
I fear
our
for him.
courtroom. And as such, the tier 1 status was not adopted till May the 22nd, because I don't believe Judge McDonald adopted it on April the 29th. Does that sound accurate to your recollection, Mr. Watson?
Thank you, Your Honor. It does. I was the one that filed the Weld findings for competency, but that does sound correct.
Okay, and so I do believe that May 22nd is accurate, Mr. Webster and Dr. Engel. And I just want to make sure if it's not designated, that this be designated a 1A, considering what happened on Monday. Things are getting worse for Ms. Stuckey, and so I do want to make sure that that designation is accurately delineated in our minute orders as well. And so that does put us at 35 days, Dr. Engel. I don't think it puts us at 38. I think you're at 35. And so you're anticipating, Dr. Nguyen, that, I'm sorry, you said May it was a 63-day wait. Are you telling me that it's probably another month?
That is just the average of all across all tier ones for the month of May. So we don't have the data yet for June, but the month before that, I believe, was very similar. So
Court
that's
Court finds today that the department is not in compliance. I do have a series of the Governor Polis's attorneys coming to observe court on July the 10th. This would be a great case for them to observe. Court sets this matter in at 4:30 in the afternoon on July 10th. That gives the department 2 more weeks to continue to work on this issue. This is the crisis. This person is suffering, and this person should not be receiving care inside of a jail, and I don't have anywhere to move her. The only option the legislature has truly provided in these circumstances is OCFMH, and this movement is not occurring the way that it was supposed to be in what was adopted into law. And so we're going to reset this matter. If somebody wants to move for contempt, you're welcome to serve them. I'm happy to take up a contempt proceeding in my courtroom. And until then, I'm just going to continue to essentially have to reset this. But certainly it will be documented, the lack of compliance. Anything else, Mr. Watson?
All right, I can set that date. I will be here.
Mr. Manchione?
Nothing, Judge. Thank you.
All right. And so, Dr. Engel and our Attorney General, I would like for you to still be present. You may be virtual at that time. And I'd like very much to know that she is hopefully moved. I don't know the circumstances of the other women. If there are that many women ahead of her, my heart breaks for those folks because I know my person, Ms. Stuckey, is in pretty dire need. So see everyone back at that date and time.
Thank you.
Betsy.
Okay, we're gonna end one more short one from her. Stop. One more short one from her, and then we're done. Hold on, I gotta find it. I got distracted real quick.
424 M3003 is present before the court. She's out of custody with Ms. Lowry here as counsel. You look really nice today.
Thank you.
Yes, I really like your dress. And I feel like you look like you have a good summertime outfit.
Thank you.
Yes, things are going so well.
Yes, they are.
Oh, and I'm, I remember we were together. I don't know the name of the person. I don't want to know the name of the person, but you had like this drama queen person that you were having to deal with, at your home. And you've done such a great job of avoiding the drama. And I told you that last time. And consistently, you still have done a great job. And so I'm really proud of you. That's not an easy thing to have to navigate, especially I know your home is like one of the apartments, but you all share a lot of the common areas. And so you're like almost like roommates in that space. You've done a really good job.
Thank you. I appreciate it.
Yeah. And I have known you for a long time. You seem like you're in a healthy place right now as far as, for the most part, the engagement that you have with Summit Stone and things that are going on. But the seizure issue has been going on for a long time. I witnessed you 2 times have a seizure when I first met you. And I know that
Or was this inmate? I got them mixed up. I went through a lot of dockets today, guys. I'm sorry.
it's gotten worse. So I was very pleased when I heard Summit Stone had arranged an appointment on July 1st for you. That is the most important thing for you to make that appointment. So all of us, particularly you, but the rest of us who care about you will understand more about what's happening so that hopefully the doctors can support and treat you, because it has been very scary for a while, and this is such an important appointment. Do you have it like written down? Like, how will you remember?
Planner, I got calendars and everything else.
Okay, Summit Stone's gonna help you get there?
Yeah.
Okay, all right. Have you ever done a test like this before?
Oh, the competency test?
No, it's an actual neurology appointment.
Well, the neurology, I've been to plenty of neurology appointments, so I'm sure it's something I've done, maybe.
Okay, so
I've been asked enough stuff, so I'm not worried about it.
okay, all right. Well, I'm hoping we get some answers there. Otherwise, please know Homeward Alliance is cheering your, saying your praises of the work you're doing. Summit Stone, you really have taken a higher road when it comes to the work you're doing in your home, doing well in pretrial services, keep connected and meeting with Nick. I mean, you're doing great. My comments to you are more of just worried for you because
Hi, Clarice.
I've known you for a long time. So I can't wait to hear what comes out of that July 1st appointment. Ms. Lowry?
Yeah, I share the court's concerns. Betsy shared that she's had a few seizures since I saw her last, but she was the one who told me about the July 1st appointment. So I know she's all about it and ready to get some answers herself. But yes, all the reports from STS, Homeward Alliance, are all very positive. And so I hope she is able to get some answers from the neurologist next week. And I'm sure we're heading towards a reevaluation at some point soon, but maybe this will help give some guidance to the evaluator.
I hope so. Mr. Manchioni?
I don't have anything to add on this one. Thank you.
All right. Betsy, anything good going on this summer?
I can't wait to see fireworks.
Okay.
Fireworks. I'm
Did you?
from Orlando, Florida, so just seeing them over here is way different anyways.
They're not as good here.
I know, I like mortar shells, so I almost want to go to Wyoming.
Oh, okay. Well, just don't bring the Wyoming here.
I know, but, well, I'm glad we're getting rain.
That's true. I agree. That makes things better. Everything's green.
I want to go fishing at the lake. I've already had my disability license and new poles, so I haven't gone yet.
So I want to tell you, there is like a lifetime fishing license.
I have it.
You do?
Yes, I do, because yeah.
I wanted to know if you
I'm
had.
disabled.
Yeah. So you did get it.
Yes, ma'am.
Excellent. What are you going to fish for?
Bass and trout
Okay.
and fun fish.
Do you throw them back, or you catch and release, or do you?
Oh, I catch and release unless there's certain poundage.
Okay.
And you can actually do something with their fillets.
Okay.
No, that's
All right.
Clarice.
Yeah.
Oh, no, it's Crystal.
Oh yeah.
I got you mixed up.
Come on now.
You're
My
Crystal,
father was
not
a veteran.
Clarice.
So there you go. I
Yeah.
don't have to say too much more to that one, do I?
No, that's very cool.
I even know how to gill them and fillet them and everything.
Wow, that's
And
great.
cook them. I had to
I'm
cook
gonna
at a young
text.
age since
I'm going to send a text to see if you can figure out who I am.
I was in kindergarten, so.
Oh my gosh. Well, I mean, that's great. I like to go fishing too. I fly fish sometimes.
I've got 50 flies and I paid $50 for 50 of them.
Okay.
And they're from 1902, the brand of them.
Well, I want to hear how things go. I hope you are able to go out and get some fishing in this summer.
Yeah.
Yeah, that's awesome. I'm really proud of how engaged you've been. Keep it up, please. And I'm going to set it out a ways, Ms. Lowry. I mean, even when the eval results come back, they'll still need some time to work through all that.
That's me texting on Twitch.
Maybe September the 4th at 4 o'clock.
It's perfect. It's the day after the day I get paid. So I get paid on the 3rd of every month.
Okay. So I'll see you right after you get paid.
Ooh.
September 4th, 4 o'clock. Thanks for all the hard work you're doing.
Thank you. I appreciate that you're my judge. I didn't think you'd be here today.
Yeah, I wasn't supposed to be here today. I run a vet's court. I've been in 2.5 days of training. I thought it was going to be a full 3 days. And then when I found out.
She has, Fozzie, before you ask, she has not streamed her vet's court yet. I haven't seen it.
Thought it was going to be done at noon. I was able to come back and finish the docket today. So I'm glad I was here so I could see you.
Oh, I'm glad you were here too so I could see you. Your hair looks very nice too.
Thank you. Yours as well. See you soon.
Would the court be willing to call the FOIA matter?
So we went through not the whole mental health docket, but a lot of it. I skipped a bunch too because, you know, the stream has to end sometime. I had other videos too. I was going to pop them in to break it up a little bit, but I didn't. I'm going to keep those for tomorrow. I don't know if I'm really happy with them. I don't know if they're great, so I just didn't. I just left it on her. Please don't do anything that you heard these people do today. Please do not do any of it at home, people. Do not. You guys should be popped right over to OJ. We still have probably today of Kato Kalin on the stand, and he's so cute. He's like a little puppy, and it's so entertaining to watch him. I'll see you guys again soon. Thank you so much for coming out. I appreciate it. Bye, guys.
Got these life echoes, digital dreams. Through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Freedom tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Her eyes near a sky so blue. In her jokes, there's a truth so true. With each stream, she brings the light. Turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Streaming tales late into the night. Her laughter feels just right.